And to discuss this further, I'm joined by our eminent guest, Dr. Adish C. Agarwal, who is an advocate of Supreme Court, and also KV Dhananjay, who is also a Supreme Court advocate. A very good afternoon to both of you, and appreciate you joining us here at Mirror Now. My first question would definitely go across to Dr. Adish C. Agarwal. Mr. Agarwal, how do you see this entire political war that has now erupted over the appointment of a retired Justice Abdul Nazeer as the Governor of Andhra Pradesh? Now, there is political parties who are questioning that within 40 days, 6 weeks after the retirement, he assumes charge as the Governor of Andhra Pradesh. Does it augur well for Chief Justices and Justices who have held one constitutional post to now be able to succeed in such quick succession, for that matter, another constitutional post as a governor? It questions the rationale behind it and that whether at all a cooling off period is required or not.
You see, actually for lower courts, like in district courts, up to district court, this cooling period is there for 2 years. A judge who has worked in that one court, he can't practice after retirement or after his transfer from that court for 2 years. But for High Court, in High Court, the judges can't practice in the same High Court forever. Likewise, in Supreme Court, they can't practice in Supreme Court. Cooling period for working in those courts, but for joining other positions, there is no bar. And this has been done not only by the present government, this has been done by different governments, like Congress also, other governments also, they have done. A retired judge are being nominated to Rajya Sabha or they are made governors. There is no legal bar. Only under the Constitution, only a person should be citizen of India, and he should be a citizen of India that is then over 35 years old. So constitutionally there is no bar, but if we want to have this amendment, then it can be done, but it will be good also, but provided for judges we should increase the age of retirement. Like we have also, as the chairman of All India Bar Association, we earlier requested the government of India to enhance the age of retirement of Supreme Court judges from 65 to 68 and High Court judges from 62 to 65. But normally every government, they say we will consider, we requested the then Prime Minister, Mr. Manmohan Singh also, and the present Prime Minister also.
Yes, sir, but that is like a different issue altogether as far as the extension or increasing the ceiling of the age of retirement. That's a different matter, sir. But what we're discussing over here is the fact that whether at all should there be a cooling off period, because even though, like you're mentioning, there is no legal bar per se that stops them from assuming charge as another constitutional post holder. But clearly, as far as the political parties are concerned, the several luminaries are concerned, they have all time and again spoken about it. Let me take that question across to KV Dhananjay, who is also joining us at this point in time, Supreme Court advocate. Appreciate you joining us here, Mr. Dhananjay. My question to you would be, do you think there is a need for a cooling off period? Because when even Ranjan Gogoi was, made the Rajya Sabha MP, the opposition raised exactly the same argument. They staged a walkout when he was sworn in as a Rajya Sabha MP during the budget session, where he had only retired in the month of November. And in this particular case, Justice Abdul Nazeer, within 40 days, he gets charged as the governor. Though no legal binding on him or constitutionally, he's not barred from assuming charge. But of course, political leaders have spoken about it, that how post-retirement jobs ends up influencing pre-retirement judgments. And this is something that has been spoken about by both Congress and the BJP.
Well, there is nobody is alleging that any particular law has been violated here. I think the problem is not that there is some positive law which forbids such an appointment and that law has been violated. The issue is much larger than that, because standards are not always determined with reference to whether there's a breach of some law. I mean, that would be a very low standard. For the judiciary has a duty to appear impartial. So the question is, how would a layperson, when he's informed about a development like this, likely to see all of this? He's likely to lose some confidence in the impartiality of justice or the judicial administration, because he's likely to think that if a judge of the Supreme Court wants or desires a posting of this nature, then that judge will have to make sure that he does not displease the government in power. And unfortunately, in this case, just in January, you had a five-judge bench, of which Honorable Justice Abdul Nazeer was the senior most judge. They ruled on demonetization and not this. I mean, this is not the development. I mean, without reference to any of this development, there has been widespread criticism of that judgment, the manner in which the matter was heard, the manner in which the court did not even insist that RBI should produce all their documents during the hearing, because what happened in that matter is the RBI, or for that matter, the central government, did not produce any document during the hearing. So that hearing was a sheer waste of public time and energy. And they provided all of those documents exclusively only to the court. The court looks at those documents and says that they are satisfied. This is more like a manner in which how a proceeding ought not to be conducted. So there was already widespread criticism, in terms of that matter, and now you have this. So question normally arises as to when did the central government start talking to the judge in question? The judge ought not to have accepted this appointment at this juncture. Perhaps the judge would have waited for a great deal of time. Again, I remind everybody that no one is alleging that any particular law has been broken, because you could scan all the law books in this country and you won't find one principle stated anywhere in that, which is no man shall be a judge in his own case. We do not believe it is necessary to make a law to state that. The law is already well settled on that. So it is much greater than the law. It's an unwritten law. So when judges finish their tenure and immediately pick up appointments from the central government, which by the way is the biggest litigant before the Supreme Court, normally people would tend to think that the judgments that courts give during their tenure, the judges give during their tenure, is more or less intended to not displease the government. Now, will anyone in the BJP say that Justice Abdul Nazeer...
Think there is a need for some sort of an amendment to be brought about? Should there be an intervention from the executive if the questions are being raised by the political leaders and MPs that such judgments, such postings for that matter, cannot be seen in isolation of their judgments that they pronounced while they were holding office as the justices? Do you think there is a need to set that order in place so that these issues do not reoccur again? Because whether it was Ranjan Gogoi earlier, now it is Abdul Nazeer, and clearly in future there's going to be a lot more.
Well, you don't always need a law, and I think this is a standard of conduct. And standard of conduct very often is not, dependent on a positive law being made to enforce that. So I believe, again, there are culprits here. The Congress government, which goes on to say whatever it's been saying, has been doing the same thing. Of course, there's always variation. Somebody just gets appointed within 15 days of remitting office. So I don't think the Congress government is the one that should be making the noise here. It's a general public. I have no political affiliation, and I would probably be saying the very thing that a common man might see. That is also being made by the opposition party. So the law, I mean, how many more laws do we make? India is already the country with the most number of laws. So laws are not going to make us better. It is just that we have to ensure that judges, it's important. If the judge is watching TV or the media, then he probably should be disappointed with the fact that the public is largely unhappy with what's just happened, because this will also tend to diminish the impartiality, the impression of impartiality.
Question across to Dr. Agarwal also. Dr. Agarwal, what Mr. Dhananjay was just mentioning over here is that eventually the people of the country, they feel let down when they see that the position that a justice holds, or a constitutional post that he holds, is not really seen as being impartial per se, because they are being rewarded politically thereafter. Do you think, Dr. Agarwal, there is a need to set an order into place? Well, you'll try and reconnect with Dr. Agarwal, but like Mr. Dhananjay was making that point across, Mr. Dhananjay, please go ahead and make that point that you were making when I interjected you.
That's okay. The central government is not going to say that Justice Abdul Nazeer would have been appointed to this post had he come down heavily against demonetization, the way in which a minority judgment in that did. The central government would never say anything of that nature. And the public is not always exposed to just one set of information. The public also gets to hear that Orissa High Court Chief Justice is not being sent to the Madras High Court because the central government is blocking it. And you have a judge, a senior most judge of the Kerala High Court,
Absolutely.
who
Let
is
me
not being elevated or
take that
sent
question
across to other
across
courts.
back to Dr. Agarwal. I would hate to interject you, Dr. Dhananjay, but Dr. Agarwal, what Mr. Dhananjay was just mentioning is that it's eventually the people of the country who feel let down, where they look up towards justices of being fair and impartial and not taking political positions, but then post-retirement, they are, rewarded politically, is where this entire doubt raises in the mind of the people. Do you think there is a need to set this in order? Should there be some sort of a rule or a convention that should be brought about to ensure this is not repeated in future again? No political party can really take high moral ground in this particular case.
I differ with Mr. Dhananjay. If judge had passed wrong order, there is a provision of review and curative petition. If you don't have faith in any judge, that is different situation. I can agree that people can make allegation that a judge who passed judgment and immediately after he has been appointed, there can be suspicion in the mind of public. Even educated, everybody can have. But this amendment has to be brought into. And you will appreciate the government alone can't come up with this. If opposition parties feel like that, the government, every government, if there is a unanimous proposal, then everybody would like to, because today more than 300 sitting and retired judges of Supreme Court and High Courts, they are on different positions in different commission and tribunals. Different acts have been, like a National Right Commission, there is a provision. Sitting judge can be, sitting chief justice can be the chairman. That was the creation of the Congress government, that NHRC, Human Rights Commission in India. So if all parties join together, I feel this can be cured and there can be better future and people have more faith.
Absolutely.
Nobody can read such.
Absolutely. Dr. Adish, C. Agarwal and KV Dhananjay, appreciate both of you joining us here at Mirror Now to discuss this a very important subject that we are tracking very closely here at Mirror Now. Thank you for joining us here.